Good morning, everybody. Thanks a lot for attending this webinar on intellectual property and the internationalization of artificial intelligence. I'm the coordinator of the Southeast Asia IPR SME Helpdesk, an initiative of the European Commission, whose mission is to support EU SMEs to protect and enforce their intellectual property rights in Southeast Asia through the provision of first-line confidential advice on intellectual property. This webinar is organized in collaboration with the European Institute of Innovation and Technology and the China IPR SME Helpdesk, whose mission is exactly the same as the Southeast Asia IPR SME Helpdesk, but for the Chinese market. I will now leave the floor to Laurent Roux, who is the Impact Officer, Entrepreneurship and Business Creation at the European Institute of Innovation and Technology in Budapest. Laurent, the floor is yours.
Thank you, Mathieu, and welcome everybody. I just want to say a few words and thank really EU IPR Helpdesk for putting together this actually series of webinars for the EIT community. This is the fourth one we're organizing with them. We have a large community of startups, scale-up, and also alumni coming out of our different programs of education and also business creation acceleration. And for them, of course, these topics of IPR are very important. And today, especially because we're talking about artificial intelligence, many of our startups, scale-up, and alumni use AI in their ventures. We actually published a report from the EIT community just a few months ago on all the initiative that we have throughout Europe using AI in collaboration also with the European Commission. So this is a great opportunity, I think, for everybody to learn, to ask questions. We have a very experienced lawyer out of Vietnam, but also with expertise in Southeast Asia, and also the China EU IPR Helpdesk is contributing to this webinar. So I think for all of you out there, just ask question, learn, and then EU IPR Helpdesk would then follow up with you with some free services that I think Mathieu will explain later on in the webinar. So thank you again.
Thank you, Laurent. I will now leave the floor to our expert. Joerg Michael Scheil is a partner of Schutz Neck Berwinkel Lawyers Office. He is based in Ho Chi Minh in Vietnam. Mr. Scheil advises mainly European industrial clients and a broad range of IPR issues in Asia. Mr. Michael, the floor is yours.
Thank you very much, Mathieu and Laurent as well, and hello everyone, and I'm glad you can join this webinar today, where we will look at IP issues arising from artificial intelligence in both China and Vietnam. Here are some of the main issues I would like to talk about today, some trends in the industries in terms of AI in both countries, also national strategies and regulations, and then a very important question, which subject matters are patentable? I will say a few words about blockchain, and we will also deal with the question, who can actually be the applicant and the inventor in an AI-related invention. And then apart from patent issues, copyright issues also play a role here, and I will end up with a few practical recommendations. So, as you all know, in artificial intelligence, sometimes it's also called machine intelligence, as contrasted to human intelligence, is often defined as a device that can perceive its environment, but not only stop at perceiving, which can also take some actions to maximize the chance of success and achieving its goals. So that is what we commonly understand by artificial intelligence. It's a very broad field, obviously, but the main industrial applications at the moment, and also in China and Southeast Asia, are telecommunications, transportation, and then also very importantly, life and medical sciences. China is very strong at defining industrial policies and national roadmaps or strategies. And we can see here actually that the Chinese State Council has already released a AI roadmap in 2017. And the goals in this roadmap are rather ambitious. China plans to become a world leader in AI by 2030 and develop the AI industry to a considerable volume and worth, and with a broad coverage of different industries from military to smart cities. This is also reflected in patent applications where not only the total number of AI patent applications increases worldwide in all major patent offices, but as you can also say, the Chinese applicants are very active, and actually institutional and academic applicants are both active. So you see the Chinese Academy of Sciences here in the top ranks, and some other Chinese universities as well. So before we go into the very AI specific IP topics, just to understand the environment and what is generally available, which IP protection is generally available in these two countries. So, of course, there is a copyright regime in China and Vietnam. China has been a member of the Berne Convention, which is probably the most basic international copyright treaty. And China has a separate law on copyright where actually a new draft is currently under discussion. In order to acquire a copyright in China, registration with any government authority is not a necessary condition, but it may be helpful or useful for evidence purposes. So it's voluntary, but you may want to do this step. It's quite similar in Vietnam. Vietnam is also a member of the Berne Convention, but different from China. Vietnam has a unified IP law, so patents, utility models, but also copyrights are all regulated under this intellectual property law of Vietnam. But then substantially principles are quite similar. Also here, registration of copyrights is voluntary and mainly for evidence purposes. But actually, as in China, the copyright itself will be generated automatically once an author has created a work. In terms of patents, there are different ways to obtain a patent in China. There are 3 types, actually quite similar to what we know in Europe or also in Germany, for example. The patent itself in China also called Invention patent. Its smaller brother, the utility model, and then also designs. Patent protection term is 20 years. And you have to go through some officially licensed agent to file an application. China is also a WTO member, and it's also a member of PCT. So all of you who deal with patent applications know PCT, the Patent Cooperation Treaty, is a framework for international patent applications. You can cover multiple countries with one patent application. And you can also choose China in doing so. which is normally an efficient way. And for European applicants, it may also be interesting to know that there is a patent prosecution highway, which basically means you can speed up certain patent applications in China, for example, by also using some office actions from the EPO and to basically forward this to the CNIPA to consider. And you see here that a standard patent application may cost you in the range of 4,000 to 5,000 euro. Always depends on how many claims you have, how complex it is, and how well the whole process goes. So in Vietnam, you also can go through PCT. So it's convenient, and then you have to enter into the national phase in Vietnam at some point in time, and then your patent application will be published. So it's fairly international standard and nothing out of the ordinary, I would say. The cost will be a little bit lower in Vietnam. Local registration cost will be lower, official cost. So you may spend between 2,000 and 3,000 euro to acquire a Vietnamese patent. It's probably fair to say that Vietnam is not, as of yet, as active as China in AI industry, but nevertheless, leading groups and companies, including the recently very well-known Vin Group, which has also started a car production in Vietnam called VinFast. They are also engaging in AI-based activities and production. And also here we see telecom, education, software, and also banking at the forefront. And it is supported by government and Ministry of Planning and Investment and Ministry of Science and Technology are supporting and encouraging companies with seminars to bring to move their AI development forward. But there have also been critical remarks. For example, a director of FPT Group. FPT Group is also engaging in software development and also actually working for example, for Japanese major customers. He said, well, in Vietnam, the AI resources are still lacking. We still need to do a bit more. And also, that's why the University of Technology has started to offer special courses on AI in order to create a broader academic basis for these activities. Right. So at this stage, I would like to hand back to Mathieu to introduce a poll question to you. So as you can see here, the poll question is, have you been involved in AI-related technologies that were developed or applied in China or Vietnam? And please give us a feedback by choosing yes or no. And we leave you a minute or so to think about it and make your choice. We also have a second poll question prepared for you. Which is, have you ever jointly carried out R&D work with a Chinese or Vietnamese institution? And here as well, please indicate yes or no. Right. I'm not totally sure whether the results are already available at this point. Yeah, here we go. Okay, currently 11% of participants have already had experience in R&D work with Chinese or Vietnamese institutions. Okay. And okay, in our audience circle today, up to now, none of you have been involved in AI-related technologies that were developed or applied in China or Vietnam. So I suppose you may be new to this, but obviously you may plan or want to prepare yourself for this option in the future, which is good to know, and we hope we can contribute to you being ready for this. Excellent. So I would continue at this stage, and we go to a very major question now. What is an invention? Obviously, we all we have a critical knowledge what is an invention, but when we talk about AI, some of our, let's say, well-defined concepts may be challenged. So the Chinese patent law teaches us an invention is a new technical solution of a product, method, or improvement thereof. The implementing regulations further add to the definition, and they also say that the technical nature is a prerequisite for a patent. So that's a very important point in connection with AI, and we will actually see the implications soon. Article 25 patent law also adds that scientific discoveries, as well as rule or methods for mental activities, are not patentable. So that's basically also in line with patent laws in other countries, where, for example, a mathematical method cannot be patented. Yeah, and that's the same in China, and then we, of course, see further implications here in the 2006 patent examination guidelines of China. It's further elaborate, and so computer programs relating only to an algorithm or computer programs per se cannot be patented. So something which is just, a process of calculation or analysis taking place inside of a computer driven by a certain software, that in itself cannot be patented in China. You have to have an add-on if you want to put it like this. Apart from mathematical methods, also methods for doing business are excluded from patentability, and also games and computer programs. So this is very much in line with European practice. The difference here is more to the US system, where this so-called methods for doing business or business process patents are not totally excluded. So the US patent law is wider here than China and US and Vietnam. Basically here, when we look at China and Vietnam, we are on relatively familiar grounds because they take a similar approach to the EU patent law. But this does not mean in Vietnam that anything related to a computer program can never be patented. Actually, if it has a, once again, technical character and it contains a technical solution to resolve a technical problem by technical means, then there is still room for a patent. Some examples are given to make this more clear. So a method for quick calculation, not patentable, but if you have an apparatus design and the apparatus or machine can implement this method, so it's basically a combination of the apparatus and the method, then there's a chance for a patent. And also a decoder for decoding a video from a data stream, this was also accepted as a patent in Vietnam. So you may begin to get a certain sense where the borderline is. Very similar in China. Computer programs per se cannot be patented, but a combination of software and hardware. So that technical results are achieved and the technical solution is brought forward, this may once again be available for patenting. And the implementing regulations in China add more details to this by saying that to require the to satisfy the requirement, you need also certain technical measures that can produce a technical effect. Okay. So there are 3 criteria. It has all has to come together to make it patentable. So very importantly, as you can see here, the Chinese Patent Office has been working on this front and added a new chapter to the examination guidelines. This also shows that they regard AI patents as quite, important and relevant, because there is a new chapter with guidelines, basically guiding the examiners in the patent office how to deal with these AI-related applications. And here we have some very clear and I believe instructive examples. We have positive and negative examples. So let's start by looking at some negative examples, some things which are excluded from patentability. One here is someone has come up with a method. We look at electricity consumption, let's say in different Chinese provinces, and then we see, oh, Sichuan has a lot of, energy consumption. So probably then we can correlate this to a positive economic sentiment. Good idea, good point, but not patentable. Yeah, it's not good enough for a patent. Just basically sampling data and doing some kind of computer-related analytics. This is not enough for a patent. Okay? Then a method where you visualize certain emotional opinions as positive, neutral, or negative, and put this into a certain layout. No patent. You know, it's not good enough because it doesn't have this very clear technical nature. So which, on the other hand, you see here in the next example, and this is a blockchain-related invention. And here, what is very interesting is that it's a combination of certain methods, but then there are these nodes, and the nodes are centralized in a network with a center which can issue and certificate the authenticity. An authorization center, and this combination of a system of authorization centers, nodes, and a communication method for blockchain, this is what makes it patentable, and I think it's a quite good example. And here we see one example from the logistics field, which it's about dispatching and a method to increase the efficiency of dispatching by notifying a batch of users in several preconceived steps. And what is interesting about this, in my opinion, it shows us that AI-related patents are available in China for the service industry. So it's not only, you know, computer companies or companies producing hardware, or it's available for logistics companies, and it's also, there is a wide application scopes in the service industry. So if we want to basically put this into some general principles, a claim shall comprise not only features with regards to business rules, but also technical features. A patent claim as a whole shall be a technical solution which comprises technical problems and a solution for solving these problems whereby a certain technical effect is accomplished. Algorithms or business methods should be arranged in a way that technical problems and corresponding effects, technical problems are solved and corresponding effects, technical effects actually achieved. Right. So who can be the inventor in an AI invention? We just said at the beginning in the definition, it's part of the AI concept. AI can not only perceive its environment, it can also take certain steps to do something in the environment. So, and this is the very nature of AI. So can AI actually be the inventor? Can AI be legally recognized as inventor in terms of a patent? Well, not yet, because the patent law in China and the examination guidelines say quite clearly the inventor can be an individual or an entity. So when you name the inventor in a patent application, you can fill in a person, a natural person, or a company, an institution, but you cannot fill in an AI itself. Although the AI may have been very instrumental in making the invention. And this is one matter of AI patent law, which is currently under discussion in the whole world. And also there is a very contentious case before the European Patent Office, where someone has tried to name an AI called Dabus as an inventor, but it has been rejected. Yeah. So the trend is similar. Who can apply for an AI patent in China? Well, the inventor. If you yourself have made an AI-related invention, you are entitled to file an application. If you work for an institution or a company, so it's a service invention, probably there are some clauses in your employment contract. And if there is not, then the general situation is if it is considered as a service invention, if you have used the facilities or equipment of the employer, then normally the right to file an application belongs to the employer. But you as individual inventor, employee inventor, need to be paid a remuneration. And there are certain guidelines for that based on the turnover, the profit, which is generated from utilizing the invention. In Vietnam, it's similar once again. An AI itself is not recognized at this moment as an inventor. And the right to register a patent can belong to organizations or individuals. And as you see here, there is also a concept of inventing on a job assignment. So this is also what we call an employee invention. So once again, same concept. Right. How is it in terms of copyright? So copyright here, the key concept, of course, is creation. Copyrights are granted for creations, for example, artistic creations, but not only artistic creations. And once again, the question is, can an AI, well, we could imagine an AI can compose a piece of music. It's technically possible, but can the AI in such case be recognized as the creator and as the owner of the copyright? Not yet. Article 11 of the Chinese copyright makes it clear citizens, legal persons, or organizations can be author of a copyright. And Beijing Internet Court, you know, there are these specialized internet courts in China, also quite interesting, which deal with matters of you know, internet related transactions and domain names and other matters. And this court has ruled that if it's a purely AI generated thing, then it cannot normally be accepted as a work, and no one will own the copyright. But if the AI owner has added further comments and analysis to the creation to basically form creation B, then the AI owner will be the owner also of the copyright. So if you further develop something your AI has been doing, then you may get a copyright for it. So I mentioned before that the copyright law is now under discussion. There is a a new draft out, and the wording is changed a little bit here from citizen to natural person, but it still means the same thing, that the AI in itself will still not be recognized as the copyright holder in the near future. And the situation in Vietnam is quite the same. You see here a list of who can be a creator under Vietnam's IP law for copyright, and authors, co-authors, and so on. AIs not in the list. Okay. Right. I wanted to say a few words about blockchain patents, because it's a currently somehow hot topic in China, but in Vietnam as well. Many people are not only investing in blockchain in Asia, as you may know, but some are also actually working on the technological aspects of it. And Tencent is one company which is apparently very active here, with 777 blockchain patents end of last year. And Alibaba is in second place. And you can see that it covers a broad range of industries, finance and taxation, where also a system of electronic official invoice, the so-called famous Chinese Fapiao, has been basically developed by Tencent and patented also. So it's also used in the public sphere, as you can see. But then there is also gaming, charity, supply chain, and healthcare. So it's a wide range, and it's growing fast. Vietnam has not yet passed any regulation with regard to blockchain in particular, but the Prime Minister has basically started off a project looking at the legal framework, to improve the legal framework, and to handle also cryptocurrencies and virtual currencies. So you can see here that it's probably safe to say that China is fairly quick in adapting the legal system to new industry trends and technological developments, also willing to experiment. You see often in China that some regulations are issued on a tentative basis, tentative regulations about this and that. Then it's used for a while. If it doesn't work perfectly, so it's replaced by another regulation. Vietnam is a bit more cautious in this, and sometimes needs a bit longer before different ministries involved have come up with new law drafts. Right. So I think when we consider all those things we have just talked about, we can draw some conclusions here, and the first set of conclusions is about probably more for those people who are actually involved in drafting patent applications. So it's if you talk to your patent attorney or your in-house patent counsel in your company or your institution, this may be a very important part for him or her. What should we pay attention to when we draft AI patent applications? I think the most vivid expression for me was here: avoid black box scenarios. So if you want to get a patent for a solution where in the patent claims, it comes across as a black box. So you put in A and you have machine B, and C comes out in a, you know, as a kind of miracle. Probably no patent examiner will be willing to grant a patent for that. The structure of the AI itself and the interaction with the environment should be clearly described in the patent application. And it should not only refer to algorithms or mathematical operations, because then, if it does, the examiner will be quick to issue an office action and say no technical content, no technical nature, and he will reject the application right away. So in order to avoid falling into this trap, you may want to make sure that it can be regarded as a technical solution. So if if the claims refer to certain features related to a device or an apparatus implementing the operation of artificial intelligence, then you get a much better chance of being accepted. Right. And another thing, it's always better to use clearly defined terms which are, you know, understandable also for third parties, not only in a very narrow circle in your company or in your industry. And don't use marketing terms, especially when we talk about certain business methods. Describing those marketing methods, those business methods by some marketing terms will not be helpful in achieving, in securing a patent. Okay. The second set of recommendation is more related to some contractual or business structure considerations. So if you plan one day to outsource certain R&D activities to China or Vietnam, let's say there are different scenarios. Let's say you have set up a subsidiary in China and Vietnam, and it's probably more likely in China at this stage than in Vietnam. Let's say you want to move past the stage of simply manufacturing some stuff. You want to develop new products. And let's say it's AI related. So there are several issues. You have to define the legal relationship between, let's say, a European headquarter or mother company or investor and the local subsidiary. For example, it could be that the subsidiary is engaging in R&D on behalf of the mother company. So you are supporting your mother company and you are receiving some development programs or development orders, and the local company is working on it and sending the results back to Europe. And then one question is, well, who will have the right to file a patent? And although there are some statutory provisions about that in Chinese law and also in Vietnamese law, better make it clear, better have a contract in place, an intergroup agreement where you stipulate clearly, you know, who should own the rights, who can file for a patent, and so on and so on. This would apply even more if it's a relationship with an outside company. So let's say there is a Chinese university and you want to collaborate with this university in some R&D, then you also need proper contracts. You need to define rights of participation, who can decide about patenting, about applications in different countries, who will own the rights, who will bear the costs. All these issues should be negotiated in advance in order to avoid unpleasant surprises. And of course, when you draft such a contract, let's say maybe you have a contract in your drawer and it has been used in the US or in Singapore or in wherever, let's say in the US. And maybe you want to keep it simple and you say, okay, we just use the same contract with our Chinese partners. Well, but it may not work the same way, you know. So you have to adapt such contracts to the local legal environment and have it checked for compliance with Chinese law or Vietnamese law to make sure that there are no invalid clauses or any content where a local court or arbitration institution in the country would say, no, doesn't work this way here. You know, this is all void, and then maybe you get a totally different result from what you wanted. Okay, and then, and this is the last point here, the internal relationship with local employees has also to be handled properly. At the end of the day, if you are a corporate organization or let's say an international research organization, it's about, you know, people, and people will generate inventions, and people will do research and development. And okay, so let's say those engineers, you have your Chinese engineers or you have your Vietnamese software programmers, and they come up with some inventions. And so you have to handle numerous different levels of legal relationships correctly. First level would be employment relation between your local company and your engineer. There are many issues you need to check. You know, it starts from, do you have proper confidentiality clauses? Do you have, for example, also a competition clause, and so on. But then more specifically, how should an employee be rewarded for AI-related inventions which he or she has made on the job? Do you have guidelines for this? Do you have a patent committee in your local company to evaluate new solutions and to communicate with the inventors in order to decide, well, this is really a good invention and we want to file for a patent based on this. Yeah. And you should have a local patent guideline in place for your company in China and in Vietnam. And once again, this local guideline has to comply with local law. So you have to check the employee remuneration regulations in the country in order to make sure that it's all valid and proper. And then once again, you also have to, as the second level, you have certain decisions like, okay, we have identified an invention here which has been developed by a local engineer. So we want to claim it, we want to use it, we want to file for a patent, but there are still many decisions. Do you want to go for a Chinese patent? Do you want to go for a European patent first, or do you want to file a PCT application? Who will be the applicant? Do you want to apply in the name of your Chinese company or your Vietnamese company? Or do you want to apply in the name of your European ultimate parent company? These will be some considerations you have to go through. Right. I hope that this gives you an overview about some of the issues which are involved when we develop the AI business in China and Vietnam. I wanted to say one word about the geographical scope here. I have focused on China and Vietnam in my presentation today because I'm practicing as an IP lawyer in these two countries. And this is why I have focused on these two countries. Of course, there are other important markets and jurisdictions in Southeast Asia. You have to consider the local law in each of these countries. Some issues, like for example, issues about patentability, expect generally to find similar issues also in other countries in Southeast Asia, like in Singapore or Thailand. But if you have specific questions about those other countries, the Southeast Asia IPR Helpdesk is there for you, and there are specialists who are knowledgeable about those particular countries, and you can direct your questions to the Helpdesk for that. Right. Okay, and with that, thanks a lot, and I would like to hand back the microphone to Mathieu.
Thanks a lot, Joerg Michael, for this interesting presentation. I remind you that this webinar is broadcasted, so don't worry. We will send you the link. It will be uploaded in our website, so that you can hear it again, or you can also share it with colleagues or any person you think could be interested in this webinar. And as Joerg Michael just said, if you have any question regarding specific country of Southeast Asia, such as Thailand, Indonesia, Malaysia, or Singapore, you can directly ask our help desk. I also remind you that you can also send us some questions, should you have some questions, because we will leave some time to answer any question you might have. And now we will display a very short interactive video, and the video will explain you how the help desk, or the IPR help desk, can help you to protect and enforce your intellectual property right in Southeast Asia and in China. And you will see also that this video is also covering Latin America, because there is a third help desk offering the same services free of charge for Latin America, so countries like Brazil, Chile, Argentina, Mexico, Colombia, and so on. So now I will leave the floor to the video. I hope you enjoy it.
Did you know that small and medium-sized enterprises represent 99% of all businesses in the EU and account for 70% of all jobs? Close to 45% of GDP in the EU was generated by IPR-intensive industries. SMEs are the motor of the EU economy. Their potential to boost employment and drive future innovation, two key priorities for the European Union, should not be overlooked. SMEs are particularly present in innovative industries such as clean technologies, healthcare, ICT, etc. Today, more and more SMEs are looking for business opportunities in emerging markets. Many of those companies are considering China, Southeast Asia, and Latin America as potential destinations. Trade relations between the EU and emerging markets have taken a new turn with the ongoing negotiation of FTAs and investment agreements. These regions are attractive destinations for European investors, with their fast-growing markets, rising middle classes, and competitiveness. Due to limited resources and available capacity, SMEs face many difficulties in managing their IP assets, and particularly when this involves IPR infringement in other regions. Intangible assets such as intellectual property rights are key factors in the competitiveness of businesses in the global economy. We have to be aware that IPR-intensive industries contributed 86% of imports and 93% of exports to EU external trade. And in developing markets such as Southeast Asia, Latin American countries and China, your trademark, patent, trade secret, industrial design are endangered. Before internationalizing your business, take an active part in protecting your assets. The International IPR SME Helpdesks are here to assist you and contribute to SMEs internationalization by the provision of step-by-step advice to build a successful IPR strategy for entering into the Chinese, Southeast Asian and/or Latin American markets. The range of services offered by the Helpdesk includes a 24-hour helpline service to reply to IPR questions, free online and on-site trainings delivered by IPR experts, free publications on various IPR topics and country fact sheets, and other useful information forms such as case studies, e-learning modules, video podcasts and more. So if you have any inquiries on IP protection, contact the Helpdesk in China, SEA or Latin America to learn how to manage your IP assets and expand your business successfully.
So I hope you all enjoyed this this very nice video. So you saw at the end of the video the email address of the helpline of the free IPR helpdesk, so you can ask any question. It's free of charge. It's confidential. So meaning if you don't want, for example, to ask any question now because it's directly related to your company, and we understand, but you prefer the request to remain confidential, then you can contact directly our helpline, and you will receive an answer in 3 working days. I don't see at the moment any question arising, but I will leave the floor to Laurent.
Okay, thank you, Mathieu. And yeah, I mean, this is a question for Joerg Michael. I think, first of all, thank for the very informative presentation. As you may know, the EIT and all the activities we we do with companies, alumni, startup, scale-up, cover a wide range of industry sectors and geographies. And I mean, you mentioned, in the case of AI, in your experience, that it's being used across industries, not just in manufacturing and the more traditional ones, but also in retail and banking and so on. So I mean, in your experience, I mean, that's my first question is in terms of volume of application and patents and activity in the AI specific in Vietnam and China, is this, you see a very big increase? I mean, this is really being now protected actively by the local players. That would maybe make it more difficult. And that would be my second question, a little bit related, is for a foreign entity to then protect its IP in this context. Is there any additional delays, cost, risk, because the local players are really active in this field?
Right. Thank you very much for your question, Laurent. Obviously, local players, especially in China, are very active in patent applications, mainly before the Chinese Patent Office, but also before international patent offices, as we can see from the statistics. And it is well known that Chinese companies can also receive subsidies from the state, especially for international patent filings. And these subsidies can be substantial. So it may be difficult in this sense for European companies or inventors to compete with this locally and for financial reasons. On the other hand, the legal conditions to obtain a patent are, well, equal and open for everyone generally, and also in line with international standards. The costs for one application are still, I mean, manageable. And therefore, the general message, of course, is do not omit or do not forget to file for patents in China and also in Vietnam, if relevant, if you have relevant inventions. It is worthwhile to seek for preventive protection, and it is always better to have a patent as your basis to proceed against any competitors as having nothing, and as having no IP rights in China. And in terms, the statistics also show that some international companies are also moving fast, and the numbers from Japanese and Korean, American, but also some European players are also going up. So definitely there is active interest in this market from all sides.
Thank you, Joerg. Maybe one more question if I have the opportunity, and I will leave also the audience to ask anything they want. But I mean, what is always great way to learn is to look at some quote unquote disaster cases, without revealing any specific of the names or the companies and so on. But I mean, people that have made really big, costly mistake by not taking certain things seriously or doing them ahead of time. So I think there's a lot, lot to learn from those case studies, if you will, not just the successful one, but the very, the ones that didn't go so well and in the end ended up costing a lot of money or preventing simply the company from doing business abroad the way they would have liked to. So I don't know if you can share a few of those without, again, revealing any specifics.
Right, sure. Well, let me highlight 2 or 3 things that I have seen a few times or numerous times. Well, some European companies are quite, active and eager to engage in some forms of cooperation, for example, with Chinese counterparts, in the hope of establishing a joint venture. And then sometimes, let's say, some of those companies are not cautious enough when it comes to disclosing or transferring certain know-how in the negotiation stage. And assuming that a joint venture will be established later, then certain things are disclosed, and at the same time, you have not obtained any IP rights for that in China, because someone in your company has said it's not worthwhile to have Chinese patents because you cannot enforce them. So then you have a very obvious protection gap, and if the joint venture never materializes, you may have, made it easier for a potential competitor to get a head start. So that's definitely one thing. The other one is in the context of what we discussed today, I would say if you start, it is very crucial when companies transit from pure manufacturing in China, for example, to a more technologically sophisticated stage in their local operations and including R&D activities. And some European companies obviously have R&D centers in China now. There are a lot of IP-related homework you need to do at that stage, and you should get it right if possible. And it includes those things which I have mentioned, having internal patent guidelines and a patenting system in your local company, and having an employee remuneration system in your local company, which is in line with Chinese law, but also in line with your corporate guidelines in Europe or in the rest of the world. So you need to have a very good alignment of what you are doing technically locally with your global IP system, and that's quite challenging. And some companies are doing a very good job, and from some companies I hear that maybe internal communication is not yet good enough in this.
Thank you. I mean, maybe one more question, because I always have a lot of questions, is because some of our companies and startup and alumni are still quite early in their development phase, let's say, so they don't necessarily have the experience or the funds to really act as a big corporation, and sometimes they consider outsourcing certain parts of their business or in the early stage of the development. And of course this has risk, as you already mentioned, I think, in your presentation. And so again, if you could just explain a little bit more, what are the risks, what are the ways to mitigate, if you're a young entrepreneur or young organization that does not necessarily have the experience or the funds to do the full protection the way a big corporation could do it. So what are the ways to mitigate that?
All right. Well, don't rush it too much. Let's say do not do not outsource anything after you have just met someone on an exhibition and then the next day you sign a contract. This is like probably rushing too much. Do some due diligence, visit the local factory, take some time to understand the whole business situation of a local partner, to assess certain competition risks also. What else is this company producing? Are they? You may believe there are only a downstream supplier, but maybe they are actually also somehow competing on your main product, and you should be aware of that. Or maybe they're exporting into France or Germany, or and you're also not aware of it. Then of course, proper contracts need to be prepared, and you need proper protection in your contracts, and those protection clauses need to be drafted with a view to the country-specific risks. It's different from Europe, obviously, and there are different risks. And just to mention one thing, that not only European companies, also Chinese companies are very concerned about key people leaving the company. If your key engineer or your sales manager is leaving the company, he or she might take sensitive know-how with him or her to a competitor establishing a new company, and then if you have not even agreed on a proper, let's say, competition clause in the contract or a penalty on absolutely no legal basis to do something against it. So you need to have a very good preventive and cautious approach, also contractually, when you set up a cooperation with a local partner or supplier.
Thank you very much.
Pleasure.
Thanks a lot for all these interesting questions. As I told before, all the questions are this webinar will be broadcasted, so all you will be able to see it again. We encourage you to share it with any person you think that could be interested in this topic. And I would like to thank again our expert and Laurent for putting this webinar together. Hopefully, we will organize more webinars with the European Institute of Innovation and Technology. I will leave the floor for Laurent to conclude. Briefly, I would really like to thank Mr. Michael from Vietnam for this very interesting and practical presentation. I know it's a very complicated topic. And again, don't hesitate to contact our helpline. We are here available to answer any question you have on Southeast Asia. If questions arise on China, please contact the Chinese help desk. And if you think that you have an issue on the subject related to any Latin American country, you can also contact our colleagues of the Latin America IPR help desk. So I leave the floor to you, Laurent, to conclude briefly.
Thank you, Mathieu, and also thank Joerg Michael for the very informative session. I don't have too much to add. I just want to say thank you to the EU IPR help desk. I think also the fact that this format of the webinar is very useful for us, for our community. I mean, people were able to join this morning, but then having the recording, we will make sure to disseminate it to the broader community of startups, scale-up, and alumni, and they can watch it offline and whenever they have the time. I think they will have some questions, so definitely, as you said, Mathieu, there is a way to reach out to the EU IPR help desk, I mean, for the different markets. So of course, in this case today was Vietnam, Southeast Asia, China, but you have a broad offering and you can help a lot of these companies, especially the young ones. They need education, they need help to get into these markets, because as Joerg Michael said, it's very specific, also very localized, and you don't want to try to do it yourself from the distance without the help of experts who are there, who've done it, who have some success stories, and also, as I was asking my question, some failures to build from, because it's never good to repeat the mistakes from others. Yeah, so thanks again. I think we will continue doing these webinars with the IPR help desk on different topics that are of interest to our community, and yeah, I look forward to that. And I think everybody in the community is very, very happy in using this format. Very useful for us. Thank you.
Thank you as well from my side.
Thank you, everybody. I see that one question just arrived. This question will be answered by email, so that we can conclude now the webinar. Thanks a lot, everybody.
Thank you.
Thank you.